is not here yet, probably still taking his lunch. If they can just be called outside.
Just take, yeah. Just a short one.
Just need to call him and find out how far he is.
Okay. Then you are excused for now.
Right? As the court pleases. Now, Mr. Inambao, before I go and deal with the charges to understand whether or not you complied with your duty to advise my clients at the time of arrest, let me just ask you a question. It appears, and I should be fair to you, yesterday you said the asset purchase agreement was just a vehicle to commit crimes, if I understood you.
That's correct.
By that time, it appears, judging from your evidence, you are not relying on it. So it's not a valid agreement, it's not enforceable, it's just that. It's not, you are not relying on its validity. How are you relying on its validity?
Can you rephrase the questions just
Yes.
to make sure that I give you a proper answer?
At the beginning of my cross-examination, I showed you how NAMCOR made an election, a choice, and did not void the agreement, assuming there was fraud. Remember, I took you to the letter by Mr. Ndeu Shiwana Ndeu Nyema.
That's right.
And I told you how he, more than a year after that, he's saying the agreement is intact, valid, and binding between the parties. You saw that?
That's right.
That is indicative of the fact that him, at that point, acting as a managing director, after accused number 1 was suspended, NAMCOR was actually relying on the validity of the agreement. You saw that?
I saw that.
You, as the investigating officer, are you relying on the validity? Let's forget about NAMCOR.
Your Worship, the evidence that the Commission has gathered is totally different from the evidence that NAMCOR was having at the time. And I want to remind Mr. Namanje that the case was actually reported by NAMCOR.
Yes, that's not the point. I'm asking you, you are not answering the question. Are you relying on the validity, yes or no?
There are two different processes, the civil part and the criminal part. From our side, we are looking at the misrepresentation, hence the charges of fraud in that regard.
Answer the question. Sir, NAMCOR relied in that letter on the validity of the agreement. You, as the investigating officer, are you relying on the validity?
Mr. Namanje, I've answered, and I've said we are looking at it from two different angles. From the angle of the criminal investigation and the criminal of civil, they are two totally different. Yes. From ours, where I stand, yes, we are looking at the misrepresentation that was done. So I can't say I'm relying on the position of NAMCOR at the time when that letter was written by Mr.
That's why I'm saying learn to listen to the questions. I'm not saying you must rely on the position of NAMCOR. I'm asking you yourself as the investigating officer. Listen to the question and do justice to your own answers. All I'm trying to say is, so are you suggesting that from the investigating perspective, you are unable to say whether or not you are relying on the validity of the agreement?
We are not relying on it, Yoshi.
Okay. But you are not telling the truth. Go to page 17 of D2, saying you are not relying on it. You actually not telling the truth. Page 17. Count 40, Your Worship.
You said page?
17,
17.
Yes. Can you just read out that count 40, fraud?
That the accused is guilty of the crime of fraud, whereas the accused did between October 2022 and December 2022 at or near Windhoek in the district of Windhoek. They did wrongfully, unlawfully, falsely, and with intent to defraud, give out, and pretend to NAMCOR, A, that he entered into a fuel supply agreement to purchase fuel from NAMCOR and agreed to receive funds from the Ministry of Defense and Veterans Affairs in Enercon Namibia, Pty Ltd's account number CHK 80235311520, an account from which Jennifer Hamukwaya, accused 3, was given signatory powers in terms of the said agreement in order to transfer the funds received from the Ministry of Defense and Veteran Affairs, while in fact the said funds were being received in a different account.
Okay, just stop there. I will ask you to go further. That fraud is predicated on a valid agreement. In other words, the charges, you are committing fraud because you committed and agreed in the agreement that the funds will be paid in this 520 account, and that on which Jennifer Hamukwaya is a signatory, in order to transfer those funds received from the Ministry of Defense and Veterans Affairs, while in fact the funds were being received in a different account. That is reliance on the agreement.
Not entirely correct, Your Worship.
Okay.
This letter that you gave to me, it refers to the asset purchase agreement. This charge relates to the supply of fuel.
No, sir. No, sir. Okay, fine. If
no, and I can qualify it.
Yeah, okay.
Your Worship, cancellation of asset purchase agreement between Enercon Namibia, Pty Ltd, Enercon in bracket, and NAMCOR Petroleum Trading and Distribution, Pty Ltd, NAMCOR Trading in bracket, Enercon's debt.
Okay. There is no, we are on the same page. No,
yes.
I know it is
So it relates to the asset purchase agreement to the amount of 53,212,000.
Sir, it's fine. We are on the same page. Just listen to the question. Have you read paragraph 5, Your Lordship, the agreement, that agreement is in the bundle of accused number 1, page 51.
Mr. Namanje, maybe before you proceed.
No.
Sir, can you just
Sir,
pause?
you are being cross-examined.
Yes. You must just be patient. You wait for the question.
Yes.
You respond, and then we move on. Mr. Namanja, which document?
51.
D
E2.
E2. File E2. May I ask one of my colleagues to provide the witness with the fuel supply agreement? E2.
At what page?
51.
51.
Asset purchase agreements.
$198, so I was given a wrong page. 198. Yes. It's page 190. Page 190. Yes, now. Okay. Mr. Inambao,
Page what?
or 190.
190.
Is the court with me? Yeah, just listen for now. Just keep that page.
It's not an objection. I'm just not sure if it's the same page because I've given him the same document, but it might just not be the same.
Mr. Nambao, just to
Maybe
assist
there's
you,
just the
185. But it's a fuel supply agreement.
go to clause 4.5 of the agreement. Okay. Just leave the agreement for now. Just listen to the question, sir. And have you kept the other page 17 on the other document?
Yes.
Okay. Now, you were suggesting that I'm talking about a different thing. It's not a different thing. Let me just say, remember I'm talking about validity. The asset purchase agreement was preceded by fuel purchase supply agreement. Is that correct? Preceded.
That's correct.
And can you read 4.5.1 of the fuel supply agreement?
The seller and buyer to enter into negotiations with respect to the purchase of all assets,
Yes.
pumps, canopy. Okay, let me open the bracket. That's
Yes.
pump, canopies, canopy, and tanks and related equipment belonging to the buyer, hereinafter referred to as equipment, at a market-related value to the established, to be established by the parties joint technical team. The parties further agree to negotiate within a reasonable time an amount that could be set off against the debt owed by the buyer,
Okay.
if any.
Okay. This agreement, you have no problem with its validity, the one that you just read. Not the asset purchase agreement. Do you have any problem with its validity as far as your investigation is concerned?
Before I answer, maybe to find out, because your question started from this document, it went to the charge, and the problem I'm having with answering the question is there is an amount written here. So, and I just want to make sure that if I'm answering, I'm not tying myself to the other.
Yeah, it's because possibly you were told what to answer. Look, I am asking a straight question. As far as your investigation, the other agreement you are saying it's not valid, it's just a vehicle. Do you have a problem with the validity of fuel supply agreement? Simple as that.
Yes, Your Worship.
Okay, so it is in the same boat as the asset purchase agreement.
That's correct.
So it doesn't matter. To you, it is a vehicle to commit criminal activity.
That's why there's charges of conspiracy.
Okay. So both of them, then you are not relying on their validity, the two agreements.
They were instruments that were used.
Yes. Then listen to the question and please keep listening. It then followed that both of them you are not relying on their validity because they were instruments, vehicle to commit criminal activities.
That's correct.
Okay, then let's go back to page 17 of D2, Your Worship. But D2, that paragraph that you read for court, you remember you read that?
Yes.
But that is based on a valid agreement because it's criticizing my client not complying with the agreement. The fraud charge is based on them committing fraud apparently because they are not complying with the fuel supply agreement. What is this?
It's correct, Your Worship.
Yes. So my client is being charged.
Know whether the witness was done answering. He was about to say something.
Okay.
I think you can just complete his answer.
Yes, sir.
Thank you, Your Worship. Your Worship, when I started testifying in the examination in chief, Your Worship, we indicated how the relationship of Enercon and NAMCOR started, Your Worship. Eventually, there were agreements that were entered into by the two entities. However, none of those agreements were fulfilled to the core.
Did you want them to be fulfilled? Did you expect them to be fulfilled?
Your Worship, that question cannot be answered now, but
When?
the expectation at the time of entering into that agreement, that should have been the case.
Okay, when you say fulfill, to be fulfilled, are you talking about performance in contract?
That's correct.
Okay, so if that is what you are saying, you expected the party to respect the agreement,
That's correct.
the instruments to commit criminal activities.
Your Worship, the
Yes.
instruments were signed
Yes.
purportedly legitimately, but immediately after they were signed, crimes were committed.
Oh, so the instruments were signed legitimately, but then something after happened, and that is the crime after the fact. That's what you are saying.
Your Worship, the crimes were committed, bribes were paid.
Listen to me, sir, and please, I think you must start thinking carefully before you answer. So you are saying the agreements were legitimately signed, and by that you are saying concluded
They were concluded, Your Worship,
legitimately.
as I testified, as vehicles to commit further crimes.
No. I'm not asking about the other statement. I'm asking about your last statement. You said they were legitimately signed. All I wanted to say, by saying legitimately signed, you are actually saying legitimately concluded. That's
Yes,
what
they
you
were
are.
signed by the parties that were involved.
Yes, legitimately so.
Yes.
Okay. And then something happened after that, and that is the start of criminal activity.
That's correct.
So then, sir, we must look after for the for the petroleum product supply agreement. We must look after its conclusion. It was concluded somewhere on the, what is the date of the first agreement? That March agreement? Was it on the 8th? Just assist, please.
16 March.
16, okay. And for the asset purchase agreement, we must look after the 18th of July.
That's correct.
In respect of each, criminality started after the fact. That's what you just said.
Your Worship, that is why on the charge you see there's a time frame
Yes.
between. I'm just looking at the charge. It says between October 2022 and December 2022.
Yes. I'm coming there now too. Oh, I didn't realize that your case is actually extraordinarily weak. Look, let's then deal with it in relation to the two clients of mine. Dealing with the criminality after this asset purchase agreement. Let's start. What is the first criminal activity after the 18th of July that Peter Arendi committed is involved after the 18th of July 2022? And I'm talking about criminal activity where he is involved. Not Malakia, Peter Arendi. Let's start one by one.
Your Worship, the criminal activity, Your Worship, is as on the charges. So, and the court has access to the charges. So if I have to explain one by one, it would have been best if you asked me, this is the charge, and then I would explain this is how.
No, sir. You told us that the agreements were legitimately concluded. What brought the problem is criminal activities thereafter. And I'm trying to assist you actually to tell them, come out so that you show your strong case. And I'm very specific. Only Peter Arendi. Let's start. You are the investigating officer.
Your
I
Worship,
cannot assist you. You are stuck, sir. I can tell you, you are stuck.
I think you are putting the answer in my mouth. Your Worship, I testified in the examination in chief that the asset purchase agreement was simply a tool or a vehicle that was used to get the money out of NAMCOR. You asked me to explain, and I'm doing that as to how the criminal activities are coming.
Okay, no, that you already told us. Remember, I'm the one, I'm not leading, I'm not your counsel. I'm the cross-examiner. I choose what I want you
But
to
Mr.
answer.
Namanje, you just told me to indicate to this court the criminal activities.
After the 18th of July involving Peter Elindi. Let's start there. Just let's start there. It's me that is cross-examining. If you cannot, then I will move on.
No. It's not that I cannot. Your Worship,
Yes.
I cannot start at the date that Mr. Namanje is giving me, because we know that Mr. Malakia signed the contract on the 15th of July.
Now, I'm not talking about Malakia, sir. Listen to the questions.
Okay.
Can you please concentrate?
You can repeat your question.
Sir, you said, even yesterday, you said it was all commercial transaction. The problem came with activities after the conclusion of the agreement. Today, just now, you said the agreement was legitimately concluded. Criminal activity started after the 18th of July. I'm representing two accused persons who are in this bail application. Let's start with Peter Elindi.
That is not entirely correct. Yesterday, I mentioned the same in respect of Erongo.
Fine, let's work with what you just said now.
Yes.
So, are you unable to start with a criminal activity involving Peter Elindi after the 18th of July? Start if you can.
Why does Mr. Namanje not allow me to start on the 15th of July? Because that's when the misrepresentation happened. And then from there, the other offenses which came in. They came in after the money, of course, was received. But why should we not start with the misrepresentation?
Say, you must be fair to all of us. You cannot be throwing us around. Now, for clarity, I asked you, when did the criminal activity start? You said the agreement, that there was nothing wrong. The agreement was legitimately concluded. The criminal activity started. You said, I wrote down, after
Mr.
the
Namanje,
18th.
as far as the evidence is concerned,
Yes.
the criminal activity started with the signing, in fact, even with the offer.
Okay.
And as well as the contract, or rather the agreement.
Mr. Inambao, I'm not representing Mr. Mulunga. Now you are back to the offer. Can you concentrate? I'm asking about Peter Elindi. Now you are going to the offer. Let me ask you a basic question.
And you know why we are having this difference, Mr. Namanje, is because the charge that you asked me to read relates to the supply of fuel.
I'm asking in general, tell us what criminal activity Mr. Peter Elindi was involved after the 18th?
After the 18th,
Yes. Let's start there.
he received, through Enercon received 53 million
Okay.
212.
I thought this 53 million was the one paid through a legitimately concluded agreement.
Hence, I insisted we go back to 15.
No. I am not interested because I'm asking you about your answer.
Mr.
Is this-
Namanje, you
Sir, can you just, maybe let's have one speaker at a time.
It's the witness,
Yes.
yeah. Look, listen. Is this the 53 million was paid in accordance with the agreement that was legitimately concluded on your version?
as the vehicle to get the money out of NAMCOR.
Okay, yes, because it's legitimately, parties must perform. You said earlier, you expected them to comply with the agreement. So the 53 million was paid.
Yes, 53 was paid.
Yes, and if one of the party doesn't comply, it has provisions what should happen.
Not when the intention has a criminal culpability. And I'm saying so because as soon as the 53 million was paid,
Yes.
we know that offenses, I mean bribes, that is from that from that money that bribes were paid, or
Okay.
kickbacks or gratifications were paid.
Just hang on there. But now you are contradicting yourself again. Now you are saying as soon as 53 million was paid, bribes were paid. So now, up to the payment of 53 on your own version, everything was fine. Bribe brought the problem. That's what you
No,
are
Mr.
doing.
Namaje. It was,
Okay.
that's not what I
Okay.
I
Why
said-
did you?
the offenses started with the misrepresentation.
Okay, we are long past that.
No, there's no way we can pass that because that's where everything started.
Okay, go back to your statement. You said as soon as 53 million was paid, what happened?
Further offenses
Okay,
happened.
further offenses happened. Let's talk about the one where Peter Arendi is involved. Did a bribe receive? I'm not talking about giving. Let's first deal with that.
No.
Okay. Did Mr. Peter Elindi, after the 53 million was paid, give to someone a bribe?
That's correct.
Okay? Park it there. That is in relation to what section of the Anticorruption Act?
35.
Okay, let's go first to understand so that I'll see whether you are making sense. Section 35 of the Anti-Corruption Act, your worship, is at page 56 of D2.
Your worship, my apologies. 34, I mean. I called it first, but again.
34?
Yes, 34.
Okay. It's fine, it's fair. Okay, can you just read it out? At page 55, your worship. Can you read it out first?
34.
Yes.
Offense of corruptly giving gratification.
Yes.
A person commits an offense who directly or indirectly corruptly offers, gives,
Yes.
or agrees to give to any person, whether for the benefit of that person or any other person, any gratification as an inducement to do or to omit doing anything, or a reward for having done or having omitted to do anything.
Okay. Remember, there is A and B. You see that?
That's correct.
The one speaks of an inducement to do or to omit doing anything, or B, a reward for having done, in other words, in the past, for having done or having omitted to do anything. Which one are you relying on?
Your worship, in order for me,
in relation to Peter.
in order for me to conclusively confirm, it's better I have a charge so that I can see which charge was used. But
No, I'm not talking about, I'm not talking about the charge that is in court, or I'm talking about when you went to arrest him. Which one were you relying on?
Your worship, I must just, if I can have the copy of the warrant, and then I can confirm.
A copy of the warrant. Look at the white bundle that I handed up today, your worship. Page 1.
Page?
Page 1. Are you there?
I'm there.
Which one did you rely on, sir, in respect of B or A or B?
We put both A and B.
Who are we?
Oh, I put, and I was saying so because I'm not the one who executed the warrant, but on the warrant of arrest, there's A and B. 34 A and B.
No. You must know your case, sir.
No, 34 A and B.
So my client, what did you explain? Did you explain both A and B?
Yes, your worship.
To Peter Elindi?
Yes, your worship.
Okay, let's go back to the section. So, in other words, you explain both in respect of inducement to do something or not to do something, and a reward for having done something or omitted to have done something. Is that correct?
That's correct, your worship.
Okay.
And before I just end it at correct,
Yeah.
when the warrant was executed, the officer had gone through the charge as
That's
it's
not
written
what-
in its entirety. So
that's not what
the
I-
explanation was done in that way as well.
No, that's not what I'm asking. Let's go to the meaningful explanation that you gave to my client in relation to 34, subsection A and B of the Anti-Corruption Commission. I will write it down. What did you tell Mr. Arendi? You said today you have done that. What did you tell him?
Your worship,
As a ground of arrest.
what was told to Mr. Elindi was that the
By-
commission,
By? What was told to Mr. Arendi by? By who?
thank you. Your worship, maybe it's best to describe how the whole process went when the arrest was effected.
No, with greatest respect, Your Worship. Sir, today you told us that you did, at the time of arrest, you sat close to Mr. Arendi when he was brought, he presented himself. You must have been with him at the ACC offices.
That's correct.
Okay? Let's then, what did you tell him about section 34, subsection A and B?
And it's what I was trying to
Okay, the start.
Your Worship, Mr. Elindi arrived with his lawyer
Yeah.
at the office.
Yes.
In this regards, Your Worship, one of the officers from NAMCOR executed the warrant in which he explained to him the grounds as to why he was being arrested.
Okay.
We were seated in the boardroom. Mr. Elindi and his lawyer were on the opposite side.
Yes.
After the officer finished, we handed him a copy. And I, on the other side, I explained, seeing that his lawyer was also there, I explained as far as to the nature of the charges.
Okay.
And I explained that, look, section 34A and B, it related to the offense of giving a gratification as an inducement of having done or as a reward for having done something. And then I explained all the other charges, Your Worship.
Okay.
Yes,
Let's
we list they were having.
Let's stick to this one. I
Yes,
will come one
yes.
by one. Yes. But that is a theoretical statement of what it say. What did you, the
Yes.
conduct, what was his conduct? What did you tell him?
It's only that you stopped me halfway.
Yes.
In fact, Your Worship, I further explained that there were money that was paid to staff members. In fact, firstly, it was, we are investigating a case of NAMCOR, where Enercon had received fuel to the amount of 35 million. And subsequent to that, there was also another transaction of 53,212,000.
No, you are going very far.
No. I'm telling you how it happened.
Yes.
And then from there, from the money that was paid out
Yes.
to NAMCOR specifically for the assets,
Yes.
there were money which was paid as gratification or an inducement to staff members.
What did you tell him about his conduct, his own conduct? You are just telling the court that there were money paid. You are not saying by whom. What did you say about his conduct that caused his arrest? What did you say?
Your Worship,
In-
when I was explaining to this, I was referring to him.
Okay, so you told him he
paid.
money.
Yes, he paid gratification.
Okay, how much did you tell him?
Your Worship, I cannot precisely say at the time as to how much was the amount that was paid, but I did say that there were money gratification that was paid to staff members. And I mentioned Mr. Willemse, where I told him that there was a 1,040,000, for example, which went into the account of Mr. Willemse's business.
So you told him, Mr. Peter Elindi, you are arrested amongst others. You paid an amount of over 1 million to Mr. Willemse. Is that what you told him?
I said there were money that was paid, Your Worship, but I remember listing one of the transactions.
But you just said, when you say paid, you are referring to my client. So did you suggest and state to Mr. Elindi that he paid Mr. Willemse? Did you say that?
I may not have said Mr. Willemse's name, Your Worship,
I thought you said...
but I did explain the charges as they are listed and said money was paid to staff members.
Sir, please don't avoid. Did you directly say to him you are being arrested because you paid gratification in the form of money? Did you say that?
Gratification, Your Worship, from the proceeds that was received from the money that Enercon had received from NAMCOR.
Yes, you are not coming. Did you say you, Mr. Elindi, paid? Did you
Your
say
Worship, I didn't tell him you, like pointing him to say you. I told him these are the charges. Money has been paid to staff members.
But by who? Because remember, the law requires you to fully explain.
Yeah.
By who? Can you...
Of course, I was talking to him, Your Worship.
Okay, so you are saying you paid.
I'm not sure as to what was the conversation, but Your Worship, he was told.
But which conversation are you referring to? I thought you are referring to your own conversation or to the conversation of the other officer when you were present. Why are you not sure, sir?
Your Worship, I mentioned the officer read the charges and gave a brief explanation. But because this was in the office, I was also there. After the officer served, I gave a background of the nature of investigations, and I tried to widen the scope as to why he was really arrested.
You tried to widen the scope to include him in charges where he has not conducted himself criminal.
Maybe widen the scope, it's a little bit
Yes.
off. But Your Worship, I explained to him. Remember, by then, his rights immediately, he was informed of the judge's rule.
No, I'm not interested in
Yes, no. I'm just saying. So we sat with him, explained to make sure that he understands, Your Worship.
Okay.
And then from there, he was given the opportunity if he wanted to say anything.
Okay. But do you know what I'm talking about? I'm talking about the ground to arrest Mr. Elindi. Should I take it that in relation to Section 34, he was never accused or told at the time of arrest that he paid somebody? He was never directly told that fact.
If he was not told the name, Your Worship, he was told that he paid bribe. And
Okay.
34 related to an offense of.
Okay. Is telling somebody you paid bribe without stating the amount and without stating the payee full explanation?
Your Worship, I know that we didn't go into the finer details of, the 50,000 and so forth and so on.
Okay.
But I know that he was informed and it was explained to him.
You are not answering the question. Is telling a suspect at arrest that you paid a bribe, but you don't say the amount, you don't say the person who was paid, is that full explanation as required by the Constitution and the CPA?
Your Worship, I know I've mentioned it to him.
What did you mention it to him? What is that?
Your Worship, I remember specifically the amount of 9.5 which went into eco trading.
You are changing.
No. I'm just saying, as we are discussing,
Okay.
and I remember the amount of 9.5 which went into eco trading. And then from there, I told him, from there the money was paid. And I remember at some point after he was charged,
Okay.
he even told me that, you see this amount. That was after now he was charged, after it was explained to him the second time.
Okay, be careful. Did you mislead my client at the time of arrest?
No.
Okay, let me ask you. Did you suggest to him that he paid a bribe of 9.5 to Eco Trading? Did you tell him that?
No, I told him about the money that was paid to eco trading.
Okay, end there. But you did not say to him you paid 9.5 as a bribe to Eco Trading. You did not say that.
And this was the money which ended up being paid into bribes, Your Worship.
Yes, by who?
Your Worship,
By who?
gratification can be paid indirectly as well.
Okay. So, but how? No. So, is the 9.5? Are you suggesting it?
That was the money that was paid out of Enercon.
Yes, to Eco Trading.
Yes.
And is it as far as between Enercon and the Eco Trading? Is that a bribe between those two entities?
That is, the money that was distributed out of eco trading.
No. Answer the question. Between Enercon to Eco Trading, is that a bribe?
Indirectly, that is the money that was used to pay the
Okay.
bribes.
Is that a cause of his arrest? Between Enercon and Eco Trading?
Your Worship, it's not the only charge. It's
No,
one
no.
of the. You asked if it's a cause. Yes, it's one of the charges. He was arrested on one of those charges.
Okay, let's go to the charge. Go to count 38. Not 38, but your lordship is the one with 2.5. Okay. Page 15, yes, count 35. Can you read out count 35? That is the 34 I have been asking you, and you are struggling to give these precise answers. Can you just read out what is the allegation, which is completely different to things you are telling us here? Read it out.
Which charge again? Count 30?
35 at page 15.
35.
Read it.
Contravening section 34A and B, read with sections 32 and 49 of the Anticorruption Act, Act number 8 of 2003, in that between 20 and 21 July, the accused person did directly or indirectly and corruptly offer money in the amount of 2.5 million to Cornelius Willemse and Jennifer Hamukwaya as an inducement for having abused their office and or positions in facilitating the purchase of 9 service stations and subsequently payment of an amount of 53,212,000 Namibian dollars by NAMCOR.
Okay. You see, let me ask you first. If you go to page 55 back, just go back to that section 34. Page 55. It says, a person commits an offense who directly or indirectly corruptly offers, gives, or agree to give.
Which bundle is that one?
Yeah, 55.
55.
Page 55. Yeah. Or what?
Just a minute. Are you there?
Yes, I'm there.
I'm trying to assist you. You see, section 34 provide 3 instances how you can commit that offense. You can offer, which is not giving. You can give, and you can agree to give. You see that?
That's right.
Which one did Mr. Arendi commit? Was it to offer? Was it to give? Was it to agree to give? Which one?
Your Worship,
Which one did you tell him?
we know that the money was paid.
Which one did you tell him?
The first question was which one?
Yes.
Eh?
Between offering, giving, or agreeing to give. That's what
Obviously, the giving, Your Worship, because the money was already paid.
Okay, it's giving.
So,
Fine.
but we know that the giving comes after an agreement because the payment was already made.
Fine, sir. Then go back to page 15 of D2. You read out the charge. It says that my client between the 20th and 21st of July directly and indirectly and corruptly offer. You see the absence of giving?
Your Worship,
Do you see the absence of
I see the absence of giving.
Okay, that's all I want. And it says that in the amount of 2.5 million, when did you advise my client at arrest of these strange allegations? Did you?
Your Worship, your client was advised,
Of this?
but Your Worship, remember when the prosecution had to draft the charges, they needed to split now the amounts. Or rather, I'm saying they needed to now look at each of the amounts.
Okay, so did you give this amount to the prosecution? Is it you who caused the prosecution to draft this charge, count number 35? Is it you?
Your Worship, drafting of the charges is the responsibility of the prosecution, but based on the evidence that was contained in the docket.
Okay. Is it you who gave them the information that Mr. Elindi committed an offense under section 34, subsection A and B, involving an amount of 2.5 by offering?
Your Worship, and hence I said giving comes after offering.
No. Sir, answer the question. Is it based on the information you provided to the public prosecutor that this offense against Mr. Elindi, suggesting 2.5 million offered, not given?
That's correct.
It's only the basis of your information.
That information is contained in the,
Okay.
it's contained in the evidence, which includes the bank statements, because by then the money was already paid.
Okay. But I'm not concerned with giving. That's not, my client is not facing such a charge. Now, when did Mr. Elindi offer an amount of 2.5 million to Cornelius Willemse and Jennifer Hamukwaya? When? When did he offer them such an amount?
Your Worship,
Do you have single evidence about that?
The evidence we have is the money that is in the accounts.
Sir, answer the question. Oh, you also said offering comes first before giving. Did you have evidence that you gave to the state that my client on a particular date offered? I'm not talking about giving, sir.
Your
Do
Worship,
you have such evidence?
the money is in the accounts, Your Worship, and that is evidence.
Sir, did Mr. Peter Arendi ever offer to Ms. Hamukwaya on a particular day, and you have information to that effect? Do you have such information in the docket?
I don't have that information,
Okay.
Your Worship.
Okay,
However, the money originated from Enercon, it went into eco trading, and then from there ultimately was distributed into the accounts of this.
That's not what I'm asking. Okay, do you have evidence? Remember, the docket will be disclosed to us at some point.
Of course.
Do you have evidence of my client offering any amount, 2.5 million, to Mr. Willemse in your docket?
No, Your Worship.
Okay.
But corruption is a crime which happens between a happy giver and happy receiver. If it wasn't because of the payments that were eventually in the accounts, there's no way we would have known about it.
Okay.
Your Worship, if it was not because this incident was reported anonymously, we wouldn't have known about it.
Okay, so you have now considered you have no evidence of offering. Let's go to giving, just to be out of caution. My client is not facing such an offense, but let's go to giving. Did Mr. Elindi give Ms. Hamukwaya 2.5 million?
Your Worship, they received 2.5 million.
That's not
That
what...
money indirectly came from Enercon.
Okay. It came from Enercon. That is common cause.
Yes.
Do you have evidence of him giving? Do you know what is giving?
Your Worship, this specific section that you made me to read, it says, directly or
Yes.
indirectly.
That we know. But all I'm trying to say, sir, a crime is committed through a conduct. Do you agree with me?
Of course.
What conduct do you interpret as giving? Tell us. When he did what? Between the 20th and 21 July. Tell us.
The money was given to, to the staff members of NAMCOR.
By who?
Indirectly from Enercon by Mr. Peter.
Okay. So, and that happened on the 20 to the 21st of July.
That's correct.
So you are actually, when you are saying you have a good case, you are talking about a 9.5 million paid, and you read out bank statement, paid to Enercon, to Eco Trading, and you are saying that is a giving to Hamukwaya and Willemse. Is that the best you could go in gathering evidence against my client?
Your Worship, that's the evidence we found.
Okay.
And if you are not happy with it, unfortunately, we have the trail of money moving from Enercon into Eco Trading, subsequently into the concerned staff member, or rather former staff members of NAMCOR.
In fact, I'm very happy it does not even begin to prove giving of money to the two persons. Now,
Your Worship, just for avoidance of these questions being put continuously, I think sight must not be lost that we are not busy with the trial now. We are busy with bail. And I think from the onset, we have already indicated that these are preliminary charges, and because it was of the insistence of defense counsel that they be furnished with charges, and the charges were drafted so that they know what charges they will be facing eventually. So I do not think we should spend much time into the technical aspects of the charges when we are not at trial. We are not at trial at the moment. We are busy with the inquiry of bail. So it's totally unfair to to subject this witness to lengthy cross-examination with regard to the issue of offer, give, the technical meanings of the word in the statute. It's unfair. I think it's the opportune time to move to another aspect.
No, with respect. No, there's nothing technical. Your worship, you know, these are elements of the offense. Judgment of S versus Unengu is very clear that the only way I can demonstrate that this story we are being told of a strongest case against our client, the case is not strong. I cannot be precluded from cross-examining the witness on the charges, because I'm cross-examining in respect of two aspects. One is to see whether indeed they explained to my client at the time of arrest, and the second one is to show that the case is weak. How else do I do it? I will never be muzzled to cross-examine a witness on the elements of the offense. My colleague must blame those who make laws. They made a law that an offense could be made, could be committed by offering, by giving, or agreeing. Those are elements. Nothing technical about it. May I proceed, Your Worship? And I'm moving to another.
You can proceed, but we must not lose sight that this is a bail application. From the onset, I've indicated the concern of this court is only the bail application.
No.
Yes,
I
so
understand
we must not lose sight of that.
I understand your lordship,
Yes.
but I cannot. Is the court saying I must not ask any question on the?
I'm saying you must not lose sight that this is a bail application.
As the court pleases.
I did not say don't put weights. I'm saying this is a bail application.
Okay.
And that is the concern of this court.
As
You
the
know,
court.
all along, even yourself have been saying to the state, this is a bail application. We are losing time. That is what I'm saying.
Okay.
Yes.
As the court pleases. Let's go to another charge, and that is count number 45. No, rather 38, Your Worship. 38,
What page?
38, page 16.
Okay.
Yes. First of all, before we even start, did you accuse my two clients of conspiracy?
Of what?
Conspiracy.
Your Worship,
Did you accuse them?
I believe count 38 relates to conspiracy.
No. I'm not asking. Did you, when you testified, accuse them of conspiracy? You must always listen to the question.
Yes, Your Worship.
Okay? Conspiracy with whom? Conspired with whom? Let's talk about both of them. Peter Arendi and Malakia. They conspired with whom?
Your Worship, they conspired with Mr. Mulunga.
Okay.
They conspired with Mr. Willemse and Ms. Hamukwaya.
Okay, those are the, so
staff
they were
members.
5 and they carried out a conspiracy, and hence that charge.
That's correct.
Okay, let's go to the charge. 38. Where is Mr. Mulunga in that charge? Where is Mr. Mulunga? This is a charge my client dealt with during their testimony. It was never suggested that they conspired with Mr. Mulunga. Where is his name?
I don't see Mr. Mulunga's name here, Your Worship.
Yes.
But as it was mentioned, these are preliminary charges.
Okay. I'm asking you on the preliminary charges because that is what the court is concerned with.
Yes.
I have no, do you want me to deal with things that that do not exist?
That's why it would have been prudent before we go into a charge, then we read the charge.
Okay, no. But you have read now. Mr.
Yes.
Mulunga is not there.
No, but Your Worship, during the arrest, we mentioned the names of all the staff members.
Fine, we take that as an abandonment because my client is not facing such an offense in that he conspired with Mr. Mulunga.
Your Worship, The agreement for the purchase of asset was concluded between Mr. Mulunga,
Okay.
Mr. Peter Elindi, and Malakia Elindi, who acted on behalf of.
Okay, but nevertheless, I thought you said you consulted with the prosecution when these refined charges were being drafted. You said that already.
Your Worship, I mentioned that I assisted in providing the information. But Your Worship, at the same time, I could see that the prosecution was heavily indebted in terms of the turnaround times as far as providing the annexures to the lawyer. So some of them, Your Worship, I can say they basically had to rush because they had to provide them over the weekend.
Okay. No, it's fine. But you read the charges you already admitted. Why did you not say, but my case is that Mr. Mulunga also conspired with the Elindis? Why did you not suggest that so that you don't end up with such?
Your Worship, if this court would remember, the charges on which the accused persons appeared on the first day, and totally different from this in terms of how many charges are there and so forth and so on.
Yes.
So meaning there was time when the state had to look into the refinement of the charges.
Yes. But it's fine. But you are not answering the question. Why did you not suggest when you read the charge to the prosecution that you left out the charges incomplete?
Your Worship, I might not have gone into all the pieces of information because of the amount of pressure that the state at the time was facing.
You were also under pressure, just like the state. Is that what you are saying now?
I had to run back and forth between my office to get documentations for them. They had to go through affidavits in order for them to formulate the charges.
Okay.
So I could see, and I remember that Saturday or Sunday, Your Worship, the team was up until 2 o'clock in the morning or 3 o'clock in the morning.
Okay. Why did you not opt to arrest after you have done with the charges with the prosecution? Why did you not choose that?
I have to object again. I do not know the relevance with regard to this aspect because, at least for now, we know they have been provided with the charges. What is this nitty-gritty of going through each and every grain of the charge? We are not busy with the trial now. And I think I've already stated from the onset what we are busy with. It's a bail application, and we should not be throwing stones to say it's the blame of this one. But I think the facts speak for themselves with regard to how this bail application has been conducted from the onset.
Your Worship, can my colleague let me cross-examine? I am entitled when a witness tells me that my client conspired amongst others with Mr. Mulunga. And I am entitled to say, but they are not facing those charges. And I'm entitled also to ask consequential questions on the answers. Why am I being muzzled to ask questions? I didn't cause such bad charges to be before court. May I proceed, Your Worship?
You can proceed.
Yes, let's go on. Let's go on. I want you to, have you done a course in understanding POCA, the Prevention of Organized Crime Act?
Yes, I've done it.
You have done so. Now, I want you to, and please, if you do not know, say you do not know. I want you to explain to court, what did you tell our client, what did my client do in relation to count 39? 39?
So what did they tell them, or what did they do?
Yes, in terms of a commission of a crime under section 4B, Roman 1 and 2.
Yes, I'm just asking because first you said, what did you tell?
Oh.
Or what did they do?
Sorry,
Yes,
I think.
just those.
Okay, sorry,
Yes.
sorry, Your Worship, I didn't realize that. I want you first to tell the court in relation to count number 39, what was the conduct of my clients that contravened Section 4B, Roman 1 and Roman 2. What is that conduct of poker?
I was looking at the 39 at the bottom, but I suppose that would be 40 because there's 239.
No, I'm asking Section 4 of poker. And that is count 39. Are you following, sir?
That's correct.
Okay.
Following.
What did they do? What is the conduct?
The conduct is disguising of in terms of the charges on the warrant of arrest, was disguising, Section 4A, disguising unlawful origin of property.
Okay.
This in the money that NAMCOR had paid to Enercon, because that money is considered proceeds of an offense.
Okay, now disguising what? Is the property involved is what? What is the property involved?
Money.
Yes, how much?
53,212,000, and then from there this money was dispersed to different accounts.
Okay.
To show that the money is legitimate transactions. This money was supposed to be for the sale of assets.
Okay, so fine.
Or rather for NAMCOR buying assets from Enercon.
Fine. So but what is Mr. Peter and Malakia's conduct? At what point were they involved in the disguising? What is the arrangement? What is the agreement? What is that?
Your Worship, fraud in this regard was committed through the misrepresentation when the contract was signed.
Okay.
And therefore the proceeds of that agreement, it's proceeds of an offense.
Okay. So, but go to page 76.
The same batch?
Yes, 76.
I'm there, Your Worship.
It refers to both, the charge referred to both Roman 1 and Roman 2. Let's deal with Roman 2. Can you read Roman 2, A and B? At page 76.
76. One is of concealing or disguising the nature or origin.
No, Roman 2, Roman 2.
I thought you said both 1 and 2.
No. I said the charge refers to both Roman 1 and 2, but I'm interested in Roman 2. Just listen to the question, sir.
Okay.
Can you read out Roman 2?
Of enabling or assisting any person who has committed or commits an offense, whether in Namibia or elsewhere.
Yes, go on.
To avoid prosecution or to remove or diminish any property acquired directly or indirectly as a result of the commission of an offense.
Of money laundering.
Okay.
You didn't complete.
Offense, commits the offense of money laundering.
Okay, now, who is the person who was enabled or assisted to avoid prosecution?
Your Worship, as I indicated earlier, when this crime was committed, I don't think people intended to be caught. So in this regard, Your Worship, that money came from NAMCOR, and subsequently, the people who processed that payment or the people who signed the agreement didn't think they were going to get caught.
No. I'm talking about the element of the offense, section 4B, Roman 2, double A. Are you suggesting that my client...
It's an objection. I don't know why it's being selectively read as only 2, but... The charge has Roman 1 and Roman 2. So I don't know why it's just one being read and the one being excluded.
I just read 1 and I'm going to proceed to 2. Can my colleague just please allow me to cross-examine? How do I start with 2?
Your Worship, I thought I started with 2.
No, you indicated you must start with 2.
No.
Roman 2.
Yes, I
Yes,
am not.
but if I understand him, he's saying the section have Roman 1 and then Roman 2.
No. I thought my colleague is no. I'm not interested in Roman because that is a different species of the offense on its own. I'm talking about 2 in respect of B Roman 1 and
Yes, I understand you, Mr. Namanje.
yeah.
But-
Rather, I'm talking about Roman 2, double A and B.
I understand you.
Yes.
Yes. But the concern from the state,
Yes.
if you understand it,
Yes.
was that you only went to Roman 2. You did not deal with Roman 1.
It's because we already dealt with the issue of disguising, Your Lordship. I didn't go to, but the witness already talked about disguising. This is a different species of an offense.
Yes,
Of
the court has no qualms with
Okay.
what you are saying.
Let me just-
But the issue is from the state.
Okay.
But then my issue is that we had earlier, even in examination in chief, there was an issue raised by Mr. Casper that in the affidavit, for example, of the 6th applicant, the state was only dealing with part 2 point something, not the other one.
Let me just say,
Can you just wait?
Yes.
So I'm coming there, yes. So this is just the repeat, because the state, for example, indicated, I am not interested in that part, I am only looking at that part. So in the same way,
Yeah.
you are also saying you are not interested in the other one,
Oh.
you are interested only in the other one, which is fine,
Yeah, okay.
because you are the one cross-examining.
Yes.
Yes.
In fact, Your Worship, I was about to remind the court that that is exactly what
Yes,
happened
the
yesterday.
court is alive.
Yes.
to the fact. Yes.
I apologize to court.
Yeah.
I didn't realize the court is with me.
Yeah.
Yeah.
So you can proceed.
Can I? All I'm trying to say in relation to Roman 2, is it your case that my client entered in any arrangement or transaction which has an effect of enabling or assisting somebody who has committed an offense to evade prosecution? Is it your case?
Your Worship, I don't think when the people or when the accused persons committed the offenses, they intended to be caught.
But listen to me. Did he enable somebody or assist somebody to avoid prosecution in Namibia or elsewhere, according to your investigation? According to your investigation, did Peter Arendi and Malakia Elindi contravene Section 4B, Roman 2? That is what I'm interested in. Are you investigating such a crime?
Your Worship, we are investigating the offense of money laundering, and in this regard, these are the charges that the state brought against the accused persons, and I believe the Roman 1 is also included, Your Worship.
No, I'm not talking about that. This offense is also money.
I rose earlier to say it's very unfair. In fact, our position has been that we are now dealing with interpretation of statutes or something when we are dealing with a bail application. In as much as he wants to confine the witness to Roman figure 2, sight must not be lost that there is Roman figure 1. So I think for the sake of fairness, being fair to the witness, he must also let the witness answer with regard to Roman figure 1, because the charge is not just confined to that.
Counsel, I understand, and the court have already dealt with that issue. The objection was overruled. You have an issue earlier on, as I've indicated.
Yes.
You confirmed before this court, I am not interested in that part. Mr. Casper rose, even the court told Mr. Casper, that is why you are here. you can deal with the other issue. So his concern is only on section 4B Roman 2. Yes.
Yes,
Yes.
I understand you, but with due respect, I'm just saying, because I think my situation was different.
I have an objection to my colleague. The court has made the ruling. He must please.
I must also not be muzzled into not objecting, because I'm also protecting my witness in as much as they were doing to the witness. So
yes, I understand,
yes.
but the court has already overruled your objection.
Yes.
So the
As
court indicated from the onset, and it's tried as officers of court.
Yes.
That is what the decorum dictates. Once the court overrules or makes a ruling, we all abide, whether you like it or not. That is the, yes. But on this aspect, Mr. Namanje simply indicates, I'm not interested in whether it's there, he's not concerned with that one. And the ruling has already been made. Yes, so can we maintain the court decorum?
Mr. Court, please.
Yes.
Okay, I want to move faster, Mr. Inambao. All I was saying is, if you are not investigating or you don't have evidence, just say no or yes. All I'm trying to say is, do you have evidence of Mr. Elindi or Malakia Elindi and Peter Arendi entering into an arrangement, agreement, or a transaction which has effect of enabling or assisting someone to avoid prosecution in Namibia or elsewhere? Simple as that.
Your Worship, as I indicated, I don't know how many times I'll have to answer. I say they did not think they were going to get caught.
But okay, fine. That's
Yes.
So that's avoiding prosecution.
okay.
Yes, can we proceed? Mr. Namanja, we are on record. The question has been put and he's giving that answer. The record speaks for
No,
itself.
I'm moving
Yes.
to another. So in that you are suggesting that the person, my client, entered into a transaction so that that person avoid prosecution. It may well be themselves. Is that what you are saying?
That's correct, Your Worship.
Oh.
That is why NAMCOR could not pay the 53,212 without any other documentation. So
Okay.
in these regards, by them entering into this agreement, they created, a record to show as if, to try and disguise that the transaction,
Okay. And it also include other accused persons. It's themselves and the other accused persons.
Of course, Your Worship.
As the person enabled and assisted to avoid prosecution.
Your Worship, I cannot confirm based on this. I'm answering in respect of this charge that you asked me to read.
Yes.
So I will confirm in respect of this case only, Your Worship. And then I will confirm when the other charges of the other individuals are put before me.
Okay. Then let's move to count 39. That I dealt with. It's actually 38 that I didn't. Is it correct that you are only relying on conspiracy in respect of Section 46, or you are relying on something else? Do you know what Section 46, or you want to look at it?
I know what Section 46
Okay.
is. You drew my attention to one of the counts here, and I'm
Yes.
still trying to find it. You're asking me another question.
Okay, no,
So
no.
I'm trying to now find a balance as to what is it that you want me to
Take
answer.
your time.
So I'm having two 39s here, 38, 39, and 39. So I just want to understand which
No,
one.
the other one is an alternative. I'm talking about 38 on top. Count
Oh, the
38.
one on...
Yes.
Okay.
So you remember Section 46A, B, and C. That's what the charge says.
Yes, that's what it says.
But if you go in the body of the charge, it only talks about conspiracy. Do you agree with me?
In the body of the charge, unless I go through it, in that between October 2021 and December 2022, the accused wrongfully and unlawfully conspired with
Yes.
Jennifer Hamukwaya, Cornelius Willemse, Olivia Dunaiski, employees of NAMCOR and representatives of EcoFuel Investment, CC and Quality Meat Supplies by inducing
Yes.
another person to VIT NAMCOR staff members herein listed to commit the offenses to VIT fraud, theft, false under pretense and money laundering. Your Worship,
So it's only conspiracy.
yes, it's conspiracy. And now, Your Worship, because I have read the charge in full, it totally makes a different context. Because if you look at the names of the people that are here, Your Worship, it's actually the people who only received cash in their accounts. Maybe that's why even this charge was drafted like this.
I don't know
I'm
why.
I'm just putting it out there.
Okay.
And hence I was emphasizing on the importance of allowing me to read the charge in full before answering questions.
I think you must learn to stick to what you are. All I wanted to say, in the body of the charge, it's only conspiracy that is relied upon, because Section 46 deal with, create 3 offenses: attempt, conspiracy, and abetting, inducing, inciting, and commanding. All I wanted you to say, it's only in relation to conspiracy. Simple as that. Not long stories.
Yes.
Okay, the question has been answered. We can move on.
Yes. Now, let me ask you, do you know the ratio behind cross-examination? Why people are cross-examined? Do you know?
course.
You know?
Of course.
Okay, do you know a duty on counsel to put as much as you put on important matter, of course, material matter, so that a witness can comment thereon? Or you do not know about that requirement?
Your Worship, otherwise I would not be here. It's because you want to elicit the truth. And that's what we are here for.
Okay. Now, my clients were in the witness box. The following was not dealt with. You spoke about Malakia Elindi living in Dubai. Remember you spoke about that today?
That's correct.
Which year did he live in Dubai? You use the word live.
Just come again with the last. Live or live.
Say, when did my client Malakia Elindi live in Dubai?
Your Worship, this was some of the intelligence that we were gathering. And the intelligence, Your Worship, went as far as finding out where is he currently. So I cannot really for now tell you when he lived in Dubai.
So you do not know when he lived in Dubai? And for how long?
That I didn't confirm, Your Worship.
Did you know, do you know if in fact he lived in Dubai?
No, Your Worship.
Why did you place it before court?
Your Worship, is bail is a formal bail application. Even hearsay evidence, Your Worship, can be admissible, and this is information that investigations received. If I hide this information from the court, I think that will be subjective in your own words, Mr. Namanje, because you did say we must be objective. And this was piece of evidence that we...
Did you intend that the court rely on such evidence, so-called intelligence?
Your Worship, those records can easily be retrieved.
So we are in court and you are testifying. When you told us today, what was the purpose for telling court that my client lived in Dubai? Did you intend that the court rely on such intelligence?
Your Worship, it's an intelligence that we received and we have provided it to the court. So it's the duty of the court as to whether they are going to allow it or disallow it.
Okay, do you trust that intelligence?
Yes, Your Worship.
Okay, why? Why do you trust such weak, such unverified, such bad intelligence? Why?
It's not totally bad, Your Worship.
Okay.
We have seen the records of the movements in and out of the country, but such could not be verified because if you look at the records of, in and out of the country, Your Worship. It basically shows you what you get on the Namibian system.
Okay. Is moving out and in of the country equivalent to living in Dubai?
Your Worship,
Is moving out and in of the country equivalent to living in Dubai according to you?
Your Worship, I said this was intelligence, but such records can be obtained.
Let me ask you an interesting question. Is it your policy at ACC just to accept anything brought there, as long as it is apparently intelligence?
Your Worship, this was happening as we were looking for the accused persons in order to apprehend them.
Okay.
So from the moment the accused persons were apprehended, Your Worship, the investigation team has not had time to verify anything, Your Worship, other than attending to, some of the issues that the prosecution team needed in order for them to ensure, for example, the bail application happens, to ensure documents are made, evidence is made available.
Okay. This bad intelligence, did you inform the public prosecutors in this bail application of such intelligence? Did you inform them?
I'm not sure, but I believe we may have discussed it. I cannot confirm that I did inform them. But I know at the time that we were looking for the accused persons.
Did you warn them that you do not even know which year accused person lived in Dubai? Did you warn them if you discussed?
Your Worship, there's no way I could have warned them if I said we didn't verify that.
Okay. Do you know that it was never canvassed with Mr. Malakia Elindi so that he can comment thereon by the public prosecutors? It was not canvassed with him. Do you know that?
No, Your Worship.
Do you know in cross-examination such an important matter on one aspect of bail must be put to the witness consent so that he can comment thereon?
Yes, it might be. It is important.
If it is important and is not canvassed with him, it is an unfair procedure. Because he was not given an opportunity when he was in a witness box.
That's how it appears to you. But
yes. And to everybody who have anything to do with justice, who like justice, anybody.
Sure.
And I expect you also to realize that it will be unjust just to throw in everything when my client has already finished testifying.
Your Worship, I was not there when your client was testifying. Okay. So I do not know a lot of details that your client may have testified on.
Okay. Now,
and Your Worship, I believe those issues, they should have been disclosed from his side.
From?
He should have disclosed them the same way. I mean, because he is an applicant.
To disclose what?
If he was living in Dubai.
How can he disclose something that does not exist?
Oh, sure.
Sir, do you know the address where he lived? You said the year you don't know, but do you know the address where he lived?
I just said we didn't verify that information.
Okay. Do you know what he was doing when he was living there? Forget about the year and the address.
Your Worship, I can answer the question 150 times if I said we didn't verify that information.
So then you verified nothing.
And that's what I said.
Okay. Now, have you seen the agreement entered into between Enercon and the Ministry of Defense in 2013? The addendum. Have you read that?
I've read it not so extensively.
Why did you choose not to read it extensively?
Initially, when we went to the Ministry of Defense,
yes,
they had only provided the current or the contract or the agreement that was in force at the time.
Oh. Initially, When you say initially, at what point are you talking about in terms of year, month, and day?
Your Worship, during 2024, when we commenced with investigations.
When did you get the 2013 addendum?
I believe sometimes earlier this year.
Okay. So then when you say you didn't read it extensively, should I take it that you are saying you didn't complete reading it, or what does it mean?
But, Mr. Namanje, you can just proceed with your questions.
No,
then
no,
I
no.
can answer them.
No. Please, can you answer the question before I ask the court to direct you to answer the question?
Mr. Namanje, I said I didn't read it in depth.
No. That's
Because
not,
the 2016 contract, it superseded all the other contracts.
Sir, I just want to understand so that I am not unfair to you. When you say you did not read it extensively, should I take it that you did not complete reading it?
Yes.
Okay. Which part did you read? Your Lordship, can, if the witness can be given D1, page 100. D1, page 100. Are you there?
Oh, I thought you were saying I must be given D1. I was waiting.
No,
Is it one of these documents?
Yeah, no, it's fine. Take your time. It's fine. Are you at page 100?
That's correct.
You see from page 100 to page 107. Is that 2013 addendum, first addendum?
Yes.
Yes. The court needs. Don't you have D1?
D2. It says D1 plus D2, but I can only see D2. D1. D1 and D2. When you look, it's supposed to contain both, but it starts at D2. Yes, so it must be the other way around. D1 first and then D2. Yes.
Now,
We can proceed.
before I start, just keep your hand at page 100. Do you know a principle in law that if a witness is not cross-examined on a particular material matter by the opponent, it must be accepted that that opponent is not disputing it? Do you know such a principle? Only if you know.
That's correct.
So in other words, if Mr. Elindi, one of them, made a positive averment saying this and that, and it's important, material to the issues, but the public prosecutor does not suggest, my instructions, the investigating officer is coming to say this, contrary to what you are saying, then Mr. Arendi must be accepted. There is such a principle. And you said you know about it.
That's correct.
Okay. Both Mr. Malakia Elindi and Peter Arendi testified that they paid over 58 million on those assets from 2013. Did you not hear about that?
I heard about it.
Okay. Would you be surprised that none of the two prosecutors
ever suggested to them that they didn't pay, as they are saying. None of them told them, no, the investigating officer is coming to say, it's the ministry that paid, you didn't pay the 58 million. In fact, they went as far and saying, we actually even took loan as Enercon. Are you surprised that such an important matter was not canvassed with my clients, yet you are bringing it up after they have finished testifying? You suggest today they didn't pay.
So, any comment?
Well, I still just need to understand where I suggested they didn't pay.
Today, you said the Ministry of Defense paid for the assets that's the subject of the asset purchase agreement, or you made a mistake?
It was not a mistake.
Okay.
There was a contract, the agreement of 2016. That was where Advocate Mulunga was reading from. And it's based on the context which is in that agreement. It was not this one.
Okay, no. I'm not even referring to this agreement for now. I say keep your hand at page 100.
Yeah, no, I'm still there.
Okay, and be careful with this one. Sir, and I will ask everybody to take note. Did any witness at the Ministry of Defense tell you that it is the Ministry of Defense that paid for the construction of those home-based stations, pumps and tanks? Did anybody at Defense, just listen, did a person at Ministry of Defense tell you that it's the ministry that paid?
Your Worship, when we had an interview with a former executive director,
Yes.
she did mention that there was an agreement with Enercon where Enercon would be recouping some of the investments that they had done.
Okay.
But the properties belonged to the Ministry of Defense.
Okay, I'm not interested in what belongs to who. I'm interested in your today's evidence. Now you are talking about the former permanent executive director telling you Enercon was to recoup its investment.
That's correct.
But that you did not testify in your evidence in chief yesterday and today.
Your Worship, a part of the document was read in which I had to comment based on the information that was read.
Okay. We have written, you suggested, I want to put it to you, you attempted to tell a lie under oath to make the case look bad against my client by suggesting that it is the Ministry of Defense that paid for those assets. You were deliberately trying to lie to court under oath because you wanted my clients to look bad.
Your Worship, I don't think I appreciate Mr. Namanje saying that I'm lying, because these words were taken from the contract, from the agreement, which is here. And this is an agreement which is signed by your clients.
Okay? Let me ask you, do you
It's not an objection, but I just want to find out from the witness if he was done answering, and if he's not done answering, he must be given an opportunity to finish his answer.
Okay. You finish, Mr.
I'm done, Your Worship, but however, Your Worship, I do not appreciate it when Mr. Namanje says I'm lying, because he saw that information came from the agreement. So if I am lying, his clients had the opportunity to go through that agreement from 2015, and it's written.
Look,
we are on record, you have already indicated.
Remember, I'm putting it to you that you attempted to tell a lie under oath when you suggested this afternoon.
No, it's not a lie.
Okay. Now, let me ask you a direct question. Who paid for those assets? The asset that are subject of that agreement, who paid? Did you investigate that?
Your Worship, there is an agreement in place, and based on the information which is in that agreement, Your Worship, which is signed by your clients, that agreement is indicating that the installation, I'm just trying to remember what was the words, Your Worship, that I was reading this morning. Installation costs would be for MOD.
Okay. Installation of what?
the assets.
Which- okay.
The document is here. We can go to the document and then see what the document says.
I'm not interested. Look, let me ask you rather this way. If the former executive director told you that Enercon was going to recoup investment, what investment did you think it was?
Your Worship, they had a fuel supply agreement with NDF.
Yes.
Part of their agreement was that they would be recouping because they had made an investment
How?
in some of the assets.
How? According to your investigation, when you make an investment in commerce, how did they make an investment which can be recouped?
Your Worship, how they made it, it was up to Enercon. But what I'm saying is, the document I was reading from, or rather the document, the agreement is here.
Okay.
So why don't we refer to the agreement and see what the agreement says and say whether it's me who's lying or it's the agreement which is lying?
No. You appear to forget that I'm the one cross-examining, not you cross-examining me.
Your Worship, it's an objection because it was actually, fault was being put on the prosecutors that was not put to the witness. So I think the witness is allowed to answer because if Your Worship can remember, this morning I was referring the witness to, I think it's clause 5 point something of the document. So in order not to blame the witness or specifically blame me, I think the witness should be allowed to explain in much detail as possible and not to cut him so that I'm made to look that I didn't do a diligent job.
Your Worship, my colleague can re-examine. Or I'm not even asking. Let me just ask you. Look, 58 million spent by my client. Do you have evidence to suggest that they did not invest that amount? 58 million.
I will not answer on that one, Your Worship.
Why? What do you fear?
I don't fear anything.
Okay. Why do you have reservation?
It's because I asked you to go to the document. You don't want to go to the document when the document is before court.
I have left that issue, sir.
Yes, sir, we have moved on.
Yes.
Yes.
I have moved
Do you
on.
have any fear?
No, Your Worship.
Okay. Any reservation?
No reservations.
Okay. So both of them, Malakia Elindi and Peter Arendi, paid, this is a positive amendment I'm putting to you,
Of course.
through Enercon. August 26 involved because it's a shareholder in Enercon. They paid 58 million. Any comment?
That's good then.
Oh, good.
If they paid 58 million, then I suppose the 53 million, half of it was also supposed to go to August 26.
That's not how companies work.
Your Worship, you just indicated August 26, Enercon both paid 58 million.
No,
Then it's fair if that investment was as such, the 53 million was supposed to.
Mr.
Sir,
Inamba,
just answer the question. The question to you was simply that the version of first and second applicant is that they, together with August 26, they paid the 58 million, and you commented that it's...
yeah, as shareholder in Enercon.
Yeah. Do you have
58
any comment? You
No
already
comment, Your
answered?
Worship.
Yes. No.
Okay. Now, let's go to then page 100 of, there is that agreement of first addendum. I want to already go to page 103, paragraph 3.1. You see that?
103, there's 3.1.
Yeah, the first
2
one.
and B's 3.
The first one, Mr. Inambawa, the first one, paragraph 2. Can you just read that?
You said paragraph 2.
No, the second paragraph, rather. The second paragraph, 3.1, is the second paragraph at page 103. Starting with DPF.
DPF undertakes to manage and pay for all remediation work, which is cost estimated to be 43 million. Namibian dollars and shall include the installation of two 23,000 liters tank and suction pumps per mod refueling sites, including installation of a fixed line network infrastructure on all home bases. DPF will source the required capital to cover the cost of remediation work and shall recoup its investment through a 15-year fuel supply contract to the MOD. MOD.
Yes.
The fuel supply contract shall come into effect immediately after both parties have signed the addendum and agreed to the terms of the fuel supply contract.
Okay. Now, that is probably what the former executive director was talking about when she told you they had to recoup their investment. It actually was more. It was 58 million. Any comment?
No comment, Josh.
Okay. And if you have a period during which you are given exclusive right to supply, that is an asset in your hands in commerce. If someone gives you an exclusive period of 2 years, 20 years, to supply 20 millions of liters of whatever, to recoup, that is an asset in your hands. Any comment? In commerce, anybody who knows anything to do with commerce? Who knows? Any comment?
Your worship, yes, it is an asset.
Okay. That's all I wanted. Now, let me proceed. Between 2013 and 2016, Enercon was busy setting up those stations. Pumps and tanks. Do you dispute that?
No.
So by the time the September 2016 was entered into, they were virtually done.
That's correct.
So in other words, when that agreement superseded this addendum, they have discharged their obligation, they have invested over 58 million.
Which should have been recouped in
Yes.
15 years.
Yes,
So from 2013, that would have gone to...
whatever period. And it's a lucrative asset.
Of course.
Okay? Now, so who has the title, the right and interest in using those pumps for those years to recoup or to make profit?
Enercon. Most definitely Enercon.
Okay. By the way, did you realize who had required authorizations and permits to operate those petroleum products in those tanks?
Just repeat the question again.
The petroleum products are regulated by law. Do you know that?
That's correct.
What is the act of parliament that you look at?
Well, I can't give you the number of the act.
Not the number. I never asked the number. I said the name.
The petroleum, just forgot the name, but it has to do with
Okay.
petroleum, Your Worship.
Fine. Did you investigate who had necessary authorization and permit in the act to operate those regulated infrastructures and assets?
We didn't go to do a physical inspection on the assets in order to determine as to who was authorized to put petroleum products there, but in terms of the agreement, Your Worship, it was Enercon.
Yes.
And with the investigations from the Ministry of Mines and Energy, it was established that Enercon was having the necessary permits, had applied for the permits to, you know.
So MOD did not have permits and authorization to operate those assets.
And we never disputed that, Your Worship.
Okay. Now, Let me then go on at page 166 of the same bundle, Your Lordship, D1. Are you at page 166?
Yes, I'm there.
Can you read 15.1.4?
15.1.4, in the event of a material breach of this agreement, Enercon shall not be limited to lodge its claim in respect of actual financial loss or general damages. Further, Enercon shall be entitled to claim consequential losses in respect of one Roman figure, costs relating to total investments made pursuant to the provisions of the agreement. Two, the remainder of the duration of the agreement based on the projected consumption of 12 million liters per annum. And three, any monthly service bureau charges payable to Enercon.
Look at this. Now, do you agree? If you don't agree with me, I'm not asking you to interpret the agreement. The court will interpret, but only if you can. This agreement suggests that in the event of a breach, Enercon can claim consequential losses, 3 heads of losses, damages. Do you agree with me?
I agree.
It will be paid in respect of the investment it put in. That is head number 1.
Yes.
It will be paid in respect of the remainder of the duration of the agreement based on the projected consumption of 12 million liters per annum. That is 2. And then it will be paid the monthly service bureau charges. You see that?
I saw it.
So, in fact, the asset comprises of 3 heads of lucrative asset, including the period.
I don't know whether I should comment, Your Worship.
Not only
because,
if you want to comment.
because we don't have a problem with this agreement.
Okay.
And we have never disputed that Enercon was entitled to these issues that are outlined here.
Okay.
That is why our investigations was not into the affairs of the agreement between NDF and...
Okay. This was a lucrative, I want to put it to you, this was a very lucrative and money-making agreement between Enercon and Ministry of Defense. Do you agree or not?
I agree.
Okay. Now, someone else started eyeing my client good and lucrative agreement. Do you know whom am I talking about? Only if you know.
Of course, you are talking about NAMCOR.
Yes. Now, are you aware of a strategic policy decision taken by NAMCOR to place it in a strategic position to be primary supplier to MOD in the long run?
Your Worship, I'm not aware of the strategic pillar or objective, but such is contained, I believe, in the submissions that was in internal memorandum that was done by Ms. Dunaiski.
Okay, let me make it easy for you. The budget, NAMCOR's trading budget for 2021-2022 included 25 million to acquire assets, and it in particular assets, Enercon assets. Yes or no?
Your Worship, I cannot confirm yes or no whether the 25 million was for particularly to acquire Enercon assets, but I can confirm that there was indeed a budget provision for 25 million for asset takeover.
But
You say,
Mr. Namanje, can you just say, can we pack it here? We roll the matter to tomorrow.
as the court please.
Yes, please.
I will. I was almost rounding up, but I think I do not want to rush to prejudice my client. I will continue tomorrow.
Yes, sir. You are still under oath. Yes. The matter is then rolled to tomorrow at 9. For continuation, applicants, you are still in custody. The court adjourns.